Reverend Father Anil. Respected Principal.
Yes.
Okay. We can start. Father, we can start.
Yes.
Then okay. Adira, we can start.
Okay, sir. Good afternoon, all. A country without a patent office and good patent laws is just a crab and cannot travel anyway but sideways and backwards. Mark Twain. A warm welcome to one and all. It's my privilege and pleasure to welcome you all into this webinar on the topic Patent Application on Innovative Academic Research conducted by the PG Department of Botany and Innovation Cell of St. Thomas College, Autonomous, Thrissur. Let's begin the webinar by seeking blessings from God Almighty. I invite Ms. Parvati Ramdas from 2nd MSc Botany for the prayer.
हमको मन की शक्ति देना, मन विजय करे, दूसरों की जय से पहले खुद को जय करे। हमको मन की शक्ति देना, भेदभाव अपने दिल से साफ कर सके, दोस्तों से भूल माफ कर सके, झूठ से बचे रहे, सच कदम भरे, दूसरों की जय से पहले खुद को जय करे। हमको मन की शक्ति देना।
Thank you, Parvati, for the soothing prayer. Now, may I cordially invite the diligent person who's been working towards the upliftment of this college, the IQAC coordinator, Reverend Father Dr. Anil Kongot, to deliver the welcome address. We welcome you, Father.
Thank you, Lindsay. Today, we are organizing a webinar on patent application on innovative academic research. India is a country where the amount of research has been increasing steadily for the last many years. And the number of research papers being published is also on the increase. But if you look at the outcome of research in terms of the number of patents and the number of startups in the country, it is still, much to sort for. I mean, much to decide for. It is often noticed that the results of many publications of Indian authors are being used by people from other countries like China to convert them into patents many a time. And according to the World Intellectual Property Organization, that is WIPO, the number of patents applications filed by India in 2019 is only 2,053. At the same time, the number of patent applications filed by a single company called Samsung is 2,334, much more than what India as a country has filed. And the number of patents filed by Huawei, another company, was more than 4,000. So we, all Indians together, could file only 2,053, patent applications. In the same year, the number of patent applications filed by China was nearly 60,000. That's 58,990. So it shows the plight of our nation when it comes to the research outcomes in terms of patents. And interestingly, our college, where do we stay? So our college has, in the recent years, I don't know what happened in the past, but in the recent years, we have already filed 3 patents One among them is by Dr. Ando PV, who is the organizer of this particular webinar. So we are happy about that, but those patents are yet to be, scrutinized, verified, and approved and published. So that is the situation. Now it is in this context that we organize this webinar on a patent application, which is very relevant for the research scholars who are doing their researches over here, because many a time we think that our research are not good enough to go for patents. But if you look at some of the patents that are coming out, they are sometimes, many a time, they are much inferior than the works done by our own researchers. So we should be courageous enough to go for patents, I hope, I believe. Okay, so my present job, my duty is to welcome everybody present here. First of all, let me welcome Dr. Father Martin K.A., our beloved principal, who encourages and supports all the positive initiatives from any corner. On behalf of everybody present here, I welcome Father Dr. Martin, our principal, to this webinar. Today's webinar is, the resource person for the webinar is none other than Mr. Vijaykumar Shivpuje, who is an expert when it comes to patents. He is the director of Patlex Business Solutions from Mumbai, a knowledge process outsourcing firm practicing in patents and designs. He's also IPR lead, IPFC Assocham from New Delhi. He's a mentor of Startup India, Ministry of Commerce and Industry, Government of India. He is a registered patent agent, Indian Patent Office. He has conducted more than 100 IPR awareness programs at universities, colleges, bar associations, incubation centers, customs office, industry chambers, and so on. So we have got the right person to enlighten us, to give us the right guidelines as to how to go about with the patent. So on behalf of St. Thomas College, the management, the students, and all the participants present here, I accord to you, sir, a warm welcome. This webinar is being organized by the Department of Botany in association with IQAC and the Innovation Cell. I welcome Dr. Vimala Jose, the head of the Department of Botany, to this webinar. I'm also very happy to welcome and congratulate Dr. Andrew PV and Dr. John Naduworth, who are the coordinators of this particular webinar. I think their efforts to bring in more innovative practices in our college and to establish incubation center in our college is truly working very well. On behalf of everyone, I welcome Dr. Andrew PV and Dr. John Naduworth to this webinar. I'm also very happy to welcome all the faculty members and research scholars from St. Thomas College and all the other institutions to this webinar. Finally, I very happily welcome all the participants, and I hope this webinar will help us understand better the nuances, the nitty-gritties of how to go about patents. I wish you all the best. I hope this webinar, produces the intended results. Thank you. Thank you, one and all.
Thank you, Father, and welcome to this webinar. Next, with great honor and respect, I cordially invite our beloved principal, Dr. Father Martin K.A., to inaugurate the function.
Hello, good afternoon to one and all. Mr. Vijaykumar Shivpuje, the resource person of the day. Dr. Vimala Jose, the HOD. Dr. Anil George K, the IQAC coordinator. And Dr. Andrew PV, the coordinator of this program. And my dear students, delegates, teachers. The present scenario, higher education institutes and their research developments are evaluated by the number of patents owned by such institutions. A patent is important simply because it ensures the protection of our invention regardless of whether it is a product, design, process, or idea. Also, patents safeguard our own ideas embodied in a certain product. It has become an important criteria to judge a researcher by his or her research outputs or innovations for the welfare of the society. An important discussion regarding patent should start from the research departments focusing the challenging researchers. The Department of Botany of St. Thomas College, Autonomous, has elevated as a research center in 2014. The department has grown up equally with other research departments in this institution, with various research activities, and has published numerous scientific papers. As patent has become a desirable measurement, this webinar, conducted jointly by Department of Botany, our IQAC, and Startup and Innovation Cell, mainly focuses on how to file a patent, spreading the way to others in research and academic field. So at the outset, I would like to welcome you all, and I wish you all the best for this webinar. And with the words, I declare this webinar being inaugurated. Thank you.
Thank you, Father, for your blessings. Now, I introduce our guest speaker for today, Vijaykumar Shivpuje, sir. Vijaykumar Shivpuje, sir, is the Director, Patlex Business Solution, a knowledge process outstanding firm situated at Maharashtra. He is a registered patent officer. He completed his M.Pharm in pharmaceutics and also completed LLB. He is currently serving as an IPR consultant with various industry chambers, academic industry, law firms, and corporates. Today, he will giving us a talk on patent application on innovative academic research. We welcome you, sir.
Yeah, thank you so much, Athira, for the warm introduction. Just before I start, just wanted to confirm once if I'm clearly audible to everyone.
Yes, sir. It's
Yeah.
audible.
Thank you. Thank you so much. So thank you so much, St. Thomas College, the autonomous institution, for inviting me for delivering this particular session. Specifically, Dr. Father Martin, Dr. Vimla, Dr. Father Anil, the coordinator for this particular event, Dr. Anto and Dr. Johns, all the joint coordinators and the student coordinators, Athira and Elsa. I take this privilege to be here, for delivering this particular session on patenting in academic institutions, or the patenting for the research, that is happening at the academic institution. To be honest, I think during the introduction, it was mentioned I've delivered more than 100 sessions actually on intellectual property rights, specifically the different types of intellectual property rights and specifically the patents. But to be honest, this is my first session, in Kerala as such, and I feel so much privileged, to have this particular session at Premier Institute, St. Thomas College. Actually, I had that opportunity to go through the kind of activities the institution has got. the activities under IQSC specifically, activities under MHRD as well as the different departments, research activities, and I feel like maybe this particular session would give you more idea about how we can actually work together as what the honorable principals have mentioned, to enhance the activities related to innovation, incubation, startup, patenting as well. When we think of all these activities, and if you look at the new education policy that has come up recently, what we observe is, till date, probably what we were expecting from any academic institution is mere teaching or some kind of research happening. But with the advancement of technology and with the new education policy, with the new regulations or the accrediting agencies like the NBA or NAC, or maybe with the rankings, RDA ranking, HL rankings, or your NIRF rankings for that sake, what is expected from academic institution is not only the research that is getting published in the research journals, but beyond that, it is very much expected from the research institution to have that research getting commercialized as well. Until and unless your research that you are doing in your lab, be it a botany lab, chemistry lab, zoology lab, or any lab for that sake, until and unless that is commercialized or that is for the benefit of the society, that research may not actually have much value. The number of research, the number of research papers may add value in terms of academic credentials, but the research that is getting commercialized, which is for the benefit of people, that is really going to add more value, and that is what is expected. In fact, with what we observe in last few years, with many campaigns like Startup India, Innovative India, Make in India campaign, what is expected is, because the reason is very simple. All those researchers, students, master students, when they go out actually after their education, because of the tough competition, probably everyone may not be in a position to get a good job. What is expected from academic institution in that case is, we need to create more job creators rather than only the job seekers. And that is what our new education policy actually, or the all these campaigns have given us the direction for the research as well. When we speak of research in academic institutions, the research traditionally has been restricted to, I would say, with respect to the research paper publications as such, and maybe for creating some funds as well. As I think it was mentioned, the concept of incubation center that has come up recently, which is making the rounds, and it's something which is very crucial when we speak of research per se as well. Because if the moment you want your research getting commercialized, unfortunately, our academic or the educational ecosystem may not have all the resources for getting that research commercialized as such. In that case, what is important is probably some collaboration, maybe with the government agencies, maybe with the private industries, or maybe with all the stakeholders that are concerned in that particular ecosystem. And we as Patlex Business Solutions have been doing these things since last 4 years, basically, with respect to various universities, educational institutions, autonomous institutions like yours, and we are working with some of the best institutions in India. Going to discuss about that as well, but the topic that has been allotted to me is more about patents. And let me just share my screen. And just once again, confirmation if my screen is visible.
Yes, sir.
Okay, great. Thank you. Now, okay, when of course it was mentioned but then beyond that, I have been recently appointed as an honorary member for Independent Expert Committee by AICT for evaluating NEET 2.0, and I'm also facilitator for the startup programs for patent filing actually by the Indian Patent Office. Been involved with various activities as such. Now, patent, when we let us also try to make it a bit interactive as well. Okay, I've just stopped sharing the screen so that I can, to start with, I can actually interact with each one of you. To start with, when you hear patent or when you read or when you learn patent, what is that one thing that comes in your mind? Can you please put it in the chat box, please? What is that one thing which comes in your mind when you hear or learn or read this word patent? Innovation, yes, Dr. Sabha. Invention, yes. What else? What else? Not discovery. Okay. Anyone else, please? Or what was that one thing that came in your mind when you saw this particular webinar happening at the institute? Yes, anyone? We speak of okay. What else? Anyone else, please? What is that one thing which comes in your mind when we think of patents as such? As I think it was mentioned, the institution has novel invention. Yes, Yogesh Nigam, novel invention, novelty, something new, basically. Right? What else? What is that? What are those things which come in your mind when you think of when you hear the word patent, basically? My memory for the word patent relates to the movie Three Idiots, basically. If someone asks me to tell them about patents, my first memory, is about this Bollywood movie by Amir Khan, which was about Three Idiots movie, wherein he has a lot of inventions, basically. And the movie shows that he has got more than 400 patents filed in his name, basically, or he has got 400 patents, basically. That's what the memory of patent is, for me. But yes, Dr. Sabha and Yogesh, what you mentioned about the patents, innovation, invention, and nor other novel inventions is something which is absolutely correct. Now, when we think of patents, that point of time, basically it's something which is granted by the government. That is, it's like a license, basically, given to a researcher. So again, these are kind of negative rights. Now, exclusive and negative rights. For you in those rights without those rights, not good for the. We always want some. Why are we getting these monopolies to the inventor? Because they are the inventions. When that has been done, should be some public kind of time. It is very we are giving you monopolies only for limited period of time. That is 20 years as such. So if we have got a patent, then for 20 years only you and you can actually use that invention. No one else, without your permission, without your license, can do that. So these are legal rights provided to you. These are rights, something which are similar to our other kind of rights. So when we speak of a license like a passport, let's say, Passport gives us a license to go beyond the country, right? Of course, with the visa. But then, similarly, they are the legal rights. Similarly, for our inventions or the research that has been done in the lab, we get exclusive rights, the legal right over that particular research, so that no one else can go without your permission. Now, what is important herein is to understand that the legal rights are only for 20 years, and they are given to an individual or the organization as such. Okay, and when I have a patent right, I can trade it, I can mortgage it, I can license it, I can sell it as well. Okay, so everything is possible as such when we speak of patent rights as such. That's why they are called intellectual property rights. You have got the so these are basically the legal rights for the creativity, your creativity, that or the product that you have developed, the process that you have developed in the your lab or a academic institution as well. Now, when we speak of patents, generally, I think one part was already covered, that is with respect to novelty. This is one criteria, one of the most important criteria for getting patent. Your invention has to be novel. It has to be new, basically. Okay, and when I say new, it need not be new in terms of the country, it has to be new globally. That is, your invention should be new in terms of so what we call it is an absolute novelty. So for example, there is a product available, let's say in UK or let's say UAE. In that case, if you are just preparing that product first time in India, in that case, still you cannot get a patent for that, because the novelty is determined as an absolute novelty. In some other countries, if it is mentioned, then in that case, that particular novelty is still destroyed. That means when you do a literature search, that point of time, it has to be a global search. That is most important. This is what we call as a novelty. Another patentability criteria is a non-obviousness, or what we call as a predictability of the art, or having an inventive step involved in that. Since we have got this webinar organized by the Botany department, let me tell you a example from Botany itself. Now what happens? There are let's say two separate species from the same genus. Two separate species from the same genus. Now, for one particular species, the species has shown certain activity in one particular what you call disease. Let's say one species shows you a activity as an antidiabetic, and what you do is you check the antidiabetic activity of the other species now. Now, what happens? Is it new? Yes, it may be new. It may be novel that this particular species was never tried for antidiabetic activities. But then it may be predictable because they are from the same genus. The species are different. The content, the content of that particular product that you are obtaining, the extract content is exactly similar. That means it is predictable. That is, there is no inventive step, or in general language, what we call, it is pretty obvious that if this species shows antidiabetic activity, the other species would also show the antidiabetic activity. Now, this is really very crucial when we speak of patentability. Because what happens technically when you're actually involved into any research as an individual, that point of time we do literature survey. Most of the times your invention is novel because you are expert in that domain. You have put so many efforts into actually having that what you call
the literature survey whether your invention is novel or not. But the secondary criteria of non-obviousness or inventive stuff or unpredictability of the art is never taken care by. And let me tell you, most of the patents which are rejected are based on this particular criteria of non-obviousness. As I said, like we are technical experts, we are not legal experts. Technically, we know the what is best in that invention. When you actually draft a patent, when you file a patent, that point of time, you need to take care of both the things. Novelty as a scientist and maybe non-obviousness as a techno-legal expert. Why I'm calling techno-legal expert? Because I understand the technology you are working in, maybe chemistry, botany, or any kind of science for that sake. And legal in terms of patents, basically. So I'm a patent agent, I'm a lawyer as well. I understand your technology and I understand the legal part of it as well. Now, when a person, like, scientist in collaboration with the techno-legal experts evaluate these things, that point of time, it would be something which would be, I would say, unpredictable, and this secondary criteria is actually met. Third, and another important criteria for patentability is industrial application, or what we also call as the utility of the invention. The patents are applicable for product, any product, or process for preparing a product. The product is either prepared by the industry or prepared for the industry. For example, if I have an abstract theory which is not resulting into any product, in that case, it is not patentable. So generally the formulas of physics, mathematics and all, they do not have industrial application on its own. But let's say there is an abstract theory. Based on that theory, you prepare a product. In that case, that product may have an industrial applicability, but the abstract theory itself may not have any industrial applicability as such. These are major patentability criteria. Now, let me just take you through, some basic questions or misconceptions about patent filing that are there, and what are actually the answers for that. Now, one of the major questions that has been asked by mostly the academicians is, when should I file the patent application? What is the right time to file the application? Do I need to actually finish up all the studies, then only I can file the patent application? To be honest, when you think of a thesis, when you think of a product basically, and or maybe as a what you call concept of a project, that point of time you can file the patent as such. If you are, so basically the moment you are ready with the hypothesis, that point of time you can file the patent for that. But then you have 1 year time to complete your application. So if you are confident enough that within 1 year you would be in a position to finish the studies, then only go for a provisional filing. Otherwise, the moment you have studies ready, that point of time you can file the patent application. One of the major requirements for patent filing is that you should not disclose your invention before patent filing. That means not on Facebook, not on Twitter, not on LinkedIn, not as a research paper, not in the newspaper, not in Hindi, not in Malayalam, not in English, or not even in Korean. None of the language. Whatever you want to file a patent, keep it to yourself first. The moment you disclose and it is in public domain, then that may act as a prior art for you. This is very important, and this is one big lesson actually for everyone. Now, one of the interesting questions when I speak specifically in the universities or academies, therein, why should I file the patent application? So patent give you monopoly rights, exclusive rights, basically. Very important for business perspective. But then, to be honest, as an academicians, most of us file the patent for maybe the accreditations, the NRF rankings, maybe some getting some credit in the our CV, basically, like, you know, as an academician, basically, like, you know, to improve our CV. And also many times these are actually factual reasons, maybe just to improve our NRF ranking, or maybe just to improve that NAC A grade to A plus. So these are, to be honest, these are the actual reasons most of my clients tell me, sir, we are least bothered how does that application work. But how do I take it? I'll tell you. Of course, for me, it is more important that you file the patent for something which can be commercialized. But then we are in an ecosystem wherein probably we should have this kind of a, I would say, practice at an academic institution to file the patents. Initially, it may be about numbers, but later on, at some point of time, it would also be about quality as well. We have to start somewhere. कहीं तो हमें शुरुआत करनी पड़ेगी. And if we do that, maybe after some years, probably, we would have something which is actually having a real value coming out of it. And in the meantime, definitely as an academic institution, as a researcher, for any of the routine activities, like I think we also have the IQC coordinator here. He would be pretty much happy to know this, like, you know, if we have this kind of practice at an academic institution. What data do I need to file the patent application? As I said, abstract idea can also be filed as a like, you know, hypothesis can be filed as a provisional application. After 1 year, once your all studies are done, you can go for the complete application. So shall I take help of patent agent for filing? I would like to answer this in like, you know, for 2 or 3 reasons you should take. First and most important reason, as I said, you understand the technology very well. You are a technical expert, but you are not a legal expert. You do not understand. I have seen many really good inventions getting killed just because they were not drafted properly. You should take help of patent agent for filing. Of course, you are allowed to do on your own. Okay, you can do on your own. Patent office doesn't require an agent like me to file a patent. This is one reason. Second reason, at some point of time for the prosecution, you would need a patent agent, because filing is maybe similar to a research document or what we call a technical document, basically. But prosecution is something which is very important, and which is something that is like, you know, I would say you need a technical legal understanding as well. So what can be done? What can be done actually is, and thirdly, of course, like that is more personal, because for me it's my business. I have to say take help of patent agents so that our business also increases. But that was on a kind of a lighter note. Can I publish my research before or after patent filing? You cannot publish your research before patent filing. That would act as a prior art for you. After, yes. For example, 9th July, I file a patent. File, not publish, now file a patent. 10th July, you can publish the research. There is no issue for that. Can I commercialize my invention after patent filing? Yes, you can do that. To be honest, as I said, patents are negative rights. They do not give you any right to commercialize your research as such. You have to go through the regulatory route to get your products approved, or the market route, basically. But what is important herein is you cannot commercialize before patent filing, but yes, after patent filing, that is possible. Cost for patent filing. So I'll tell you about the costing part actually. Like, you know, the patent office has 2 layers basically for patent filing. One as academic institution, one as an individual inventor. Now, if you file it as an individual inventor, the costing is comparatively lesser. For the college, it is 5 times higher actually compared to the individuals. Government of India has also come up with a recent draft proposal wherein all the government institutions or aided institutions, for those, there would be a reduction in patent filing fees. I'm not sure. Maybe someone can just let me know if the institute is a government aided, or is it a government institution? Yes, Athira or Dr. Anto?
Yes, sir.
Is our institution a government institute?
Aided. It is government aided.
Okay, government aided. Then St. Thomas would be eligible for this, wherein, of course, it's in a draft proposal, wherein you would be eligible once it is approved, that a particular draft is enacted. That point of time, there would be a reduction in fees for you as well. Can I file patent application without telling my institute or guide? Wow, this is a common question. Many people have come to us with this particular question actually. Yes, you can do that if the institution doesn't have an IPR policy in place. We have the IQAC coordinator here. If the institution doesn't have an IPR policy in place, make an IPR policy. It is going to help you solve all these issues, as well as it is going to help you in your accreditation as well, or your rankings as well moving ahead. Now, these are, and can someone else file patent application of my invention? Yes, absolutely. For example, in the same lab, two people are working, and this has happened actually. These are live examples. Someone else files the invention, and the first person even doesn't know. There is a legal way to tackle it, but then probably who is going to take that legal route, basically, right? But yes, it is feasible, but then it can be circumvented as well later. Now, what happens? Application gets published. So when we speak of application, patent once filed, we know why we are filing, what is that invention, what are the criteria for filing and all. It gets published automatically after 18 months. To get a patent granted, generally, so a day before yesterday, we got a patent granted, which was filed in 2017. 4 years time, we got the patent granted. There is an expedited examination available now for government institutes, startups, female inventors. Therein the patent may get granted within 1 year as well. Is publication of application, does it assure grant of patent? No, it doesn't. There are two publications in case of patent, one as an application and the other one as a grant. What is the cost after patent filing till grant? In case of academic or individuals, the cost may be anywhere between 60 to 70,000, entire cost spread over 4 to 5 years, and then we would have for academic college, if we are filing, in that case there may be a cost which is on higher side up to 1 lakh. Now, can I commercialize the invention after grant? As I said, after filing also you can do. Now, one of the major I would say misconception about patent is that if I get a patent granted, someone is going to come to me, get my patent licensed, and I would be Funsuk Wangdu. If you know who is Funsuk Wangdu, the character in the movie Three Idiots, which was based on Mr. With the same name actually, it is not the patent that would be actually sold in the market. It is the product. If your product has some value, then only your patent would get licensed. If your product is sellable, then only the patent is just protecting that product. Then only you would be in a position to get a license for it. Now, what is the difference between a design and a patent? Of course, I think this is the session is restricted to patents. I'll just stick to patent, but then what we have is another type of intellectual property right called industrial design. There are, of course, others like copyright and trademark and geographical indication as well. But patent is something which is most crucial as far as research institutions are concerned. Now, if I compare, most of us, every one of us rather, knows what is a research paper and what is a how is it actually published as well. In case of Patent, the difference is few. There are certain differences between a patent and a research paper. Like in case of patent application, there is no evaluation before publication. Anything you file gets published. In case of research paper, there is an analysis. Research paper, you don't need to pay fees as such. But nowadays, there are journals who are asking for the fees as well. Now, research paper gets published, once the publication timeline is variable. Normally, a patent application gets published after 18 months, and in early publication, it may be a week as well. Now, research paper gets published only based on novelty. In case of patent, you have non-obviousness. The secondary criteria is the most important. Now, the rights as an author, you have rights, global rights, but then in case of patent, you have the legal rights. That means what happens? For example, one of the faculty members discovers a wonderful product and he publishes it as a research paper. And I come to know, okay, this is a great product. He doesn't have a protection. I can sell it. You can't stop me selling it. But if you have a patent for that, I cannot sell it. You can legally stop me from selling it. Now that's how it is commercialized. As I said, the jurisdictional rights are there, and one of the most important thing in research paper generally we see is the results. That is more important. In patent application, what we have called is a claim. What are you claiming? That is the most important. I remember when I was doing my master's, that point of time, my research guide mentioned me to read a lot of research papers so that I can draft a research paper. Same thing applies here. You need a practice to draft a research paper or draft a patent application as such. Now, once we file that patent application, it goes through a certain process. But as I said, novelty is something, or obviousness is something which is very crucial. We need to take care of it. Most of the times, incorrect claiming, especially if you are filing on your own, if there is no, I would say, agent involved, many cases we have these issues actually. Then there are written description problems, non-patentable subject. Again, many of the times it's all because the applicants or researchers are filing on their own rather than getting any external help. Now, there are many inventions which are not patentable in India, and the most important three are the ones which are in the red, examples. So, for example, I'll stick to the examples of herbal research or botany because, these are the three sections, 3E, 3I, and 3P, which are mostly concerned to that. Now, an admixture of two herbs is not patentable, but if you have synergy, then they are patentable. And now everyone knows, those who are in research, what does it mean by synergy basically. So combinations may be patentable if they show a synergy basically. Then second, medical use. So for example, there is a product or a herb which was known for a treatment of a disease. You are trying it for some other, then it is not patentable. How can it be done? It can be done only in the garb of a product, end product, not for the medical use. So that is the second thing. Third important thing, traditional knowledge under section 3P is not patentable. But then if you convert that into a modern dosage form, so for all your botany research, all your herbal research, you are taking extract and checking the activity, right? That is all fine. But if we take that extract and convert it into a simple powder or a granule, or let's say a tablet for that sake, or a capsule for that sake, in that case, it may be for sure patentable because modern dosage form is not a traditional knowledge basically. The modern dosage form with your earlier knowledge of a particular herb, in that case, it would be something which would be patentable. We have live examples. These are some of the granted patents. in India which are for herbal inventions. Like this number, if you see 295171, this is for a combination herbal composition which is for the treatment of epilepsy, anti-epileptic. Composition comprises, now look at these. It has a curcuma longa, that is haldi as well. Now people say haldi traditional knowledge hai for any disease, it's known since the ages, but in combination with these it may not be known. And if this has been granted just because of the combination as well as the percentages, the end product. Okay, now another example wherein you have excipients added to it. So what is important is that knowledge, like, now they have this Capparis siparia as a herb which has been used for nerve disorders treatment or neuronal injuries, along with excipients. That is what makes it a invention which is patentable. So what is important is research is one part, putting that research in the proper format of patent. That's the reason you need a patent agent for that. We have herbal oil composition, like another example in controlling blood sugar. I said medical method of use is not patentable, but herbal oil composition in controlling blood sugar, anti-diabetic kind of stuff, without risk of hypoglycemia. Now this is something which is patentable. Now, if you go to the clinical part, basically in that case, like, we know, of course, most of the research in botany has been restricted to preclinical, I would say. But if you're aiming for actually clinical studies for any of the product, there are many things in that, like, for example, dose determination, dosage for determination, dosing regimen, method of administration, the metabolite and method of treatment. Some of them may not be patentable in India, but yes, in many cases they are the ones which are also patentable in in the domain of herbal research as such. So this is something which is important in terms of herbal research patenting, or I would say patenting with respect to specifically the academic institutions, those who are working in the botany or any other department, that would be something which is important. I'm done with my presentation as such. I have few slides, I'll share it later, but before that, I want to know if there are any specific questions for me. I have few slides telling about the Patlex as an organization, what we are doing, how we can help you and all. But then before that, I would like to actually take any technical questions if there are any.
Anyone can ask questions regarding our doubts for patenting. Hello. Any
Yes, sir.
questions? Any questions regarding the patent application? So that Vijaykumar sir can proceed such a way that otherwise he will try to speak about the steps of patenting.
So I think there is a question in the chat box about job opportunity in India for IPR. I think, to be honest, if we speak of the job opportunities, there are immense opportunities because we still are not in, we are still a manufacturing-based economy rather than innovation-based economy. We are moving in that direction, and as we move on, there would be more requirements for professionals who are techno-legals, those who are someone who actually is understand the technology as well as the patent part. There are opportunities with government, the universities, the private industries. If you can practice as an individual independently, like the way I am practicing, government of India is also coming up with lots of opportunities with at many institutions, the IPR cells, So there are lots of things happening as such on the IP front as such. The government labs, CSIR labs, all these big institutions, as I think it was mentioned in the introduction part, we need more number of patents being filed, and there would be definitely more requirement of people who are patent experts as well, which is also something really crucial. So before I like actually conclude, let me also mention about the activities that we are involved into with respect to academic institutions. Okay, so we as a Patlex Business Solutions are involved into patent filing prosecution. We are also involved into startup innovation and entrepreneurship related activities. How I'll tell like in the next slide. We also have lots of joint courses with the IQSCs or IIC related activities we are conducting at many institutions. As I said, I had that opportunity to visit the website of the institution as well. So we are already connected with 35 plus institutions, autonomous institutions, individual colleges, deemed universities, 5 universities we are working with. We have 100 plus patents filed and 9 granted as such. We are working with, since the institution's website actually mentioned about the NRF ranking, we are working with Hansraj College, New Delhi, which is ranked 9 in NRF all across India in science category. We are working with Bombay College of Pharmacy and BNCP, which are among top 30. And of course, we are also working with St. Xavier's College, Mumbai, ranked 90, but it is one of the premium most institutions in Mumbai as such. And therein we are working with, now this is one example how we are working with Hansraj College. In fact, tomorrow we are starting with this particular one of its kind of program on innovation, IP, startup and entrepreneurship. It's just not about IP, it's just a tip of the iceberg. The startup ecosystem, the incubation ecosystem, how startup fail, how startup grow, all these things we are discussing with some of the best eminent experts. This is kind of our team basically who is taking care of all these activities at the Hansraj College, startup co-founders, someone from Edelweiss who is into finance, and as well as we have people from incubation center. Basically they are all trainers and startup co-founders and all. So that's what just to mention about our activities as such. As I said, I would be happy to take any questions again, but then if there are no questions, I think I should thank all of you, especially Dr. Anto, for providing this particular opportunity, the institution, the organizing committee and the management, the honorable principal sir, every one of you for hearing for an hour in the afternoon basically, and hope to see you soon. Take care of yourself and stay at home. Thank you.
Thank you, sir. Sir, I have a question. And sir, here is a question for you in the chat box.
Find out the, okay, I think that's a very interesting question. A property for, as let's say anti-diabetic of a plant patentable, or should we find out the principal component? Now the answer to this is very tricky. Thank you so much, Gitu, for asking this particular question. See, to be honest, you may not need to identify that principal component as such. If you know the category, that would also be sufficient. But again, with a disclaimer, what is known in the art, that is more important. How much study you have to carry out, that is all dependent on what is already known in the art. So for example, that plant having anti-diabetic activities known in the art, then you go for actually the principal component. Okay, these are the glycosides which are showing this activity, then that is required. But if that plant is not known for anti-diabetic activity, then yes, you need not go for the identification of that particular principal component. I think that clears your doubt, Gitu.
Thank you, sir, for answering the question. Sir, I have one more question to ask you. Can I?
Yeah, please.
Sir, I have heard about same title and different patent numbers.
Hmm.
It's a general question. And what's the purpose of that?
No, so actually, to be honest, you can get two pins with the same title. That is absolutely fine. Okay, it's like I'll tell you an analogy for everyone. Athena, can you mute yourself?
Sorry, sir.
Yeah. Okay. I'll tell you an analogy. There would be two people with the same name. Is that correct? Yes, there can be two people with the same name, but they are different individuals. Similarly, two patents with the same title, but there would never be two patents with the same claims. The patent is the scope of the patent is restricted to its claims. Okay, so there would never be two granted patents with same claim with the same title, even with the same abstract is absolutely fine, but same claim is not possible anywhere. Okay, yeah.
Thank you, sir. So, any other questions?
Question. So, part for 20 years, everyone, anyone can use monopoly after it cannot be it's
Thank you. Any other questions?
That is it the monopoly?
it's a jurisdiction. So getting granted in India, at least it will be restricted only if you want your invention not to be copied in other countries. You will have to. There is nothing called a global patent. Basically, we just have a PCT filing system, global filing system, but there is no global patent per se. So you that is restricted to that country, and thereafter you need to take care of so you have to file in each of the country wherever you are interested.
Okay, thanks. Okay.
Yeah.
Any other questions?
Oh wow, Angel Davis. I was expecting anything really something related to COVID-19 actually. This has been one. I think, when we speak of patents, basically the monopolies, exclusivities being created, and generally there has been, especially for the pharmaceutical patents, basically or the in the life sciences, there has always been a resistance, but then let me tell you, the cost for developing a new drug or a vaccine is really very high. And but Angel Davis, there is a provision under Patent Act in case of emergencies like this, medical emergencies, health emergencies. So, for example, I think few years back we had unfortunately a very big flood in Kerala, if I'm correct, right? Then in those kind of cases, government can give the license to everyone for actually production of the vaccine or the drug for export and import, and the same thing has happened. Forget about government doing it, even the pharma companies during these times have been doing great job in terms of not restricting the knowledge or creating the monopolies through patenting, but rather making sure that everyone, each one of you, is getting access in terms of the vaccine or the drugs that are actually required. So to be honest, COVID is one of its kind of crisis that we are facing currently, and therein fortunately patent has not created any issues. That's the reason we have so many technologies with respect to diagnostics, treatment, prevention that are available. Yeah.
More questions? Sir, I think the discussion session is done.
Yeah.
And
Okay. Thank you. Thank you, everyone.
thank you, sir. The session was very informative, and your presentation helped us to familiarize with the field, with this field, and also to clarify our doubts about patent application. Thank you, sir. Once again, thank you, sir, for your valuable time and informative words. Now, the feedback form for the feedback form is available in the chat box. All of the participants are requested to fill the form for receiving certificates. Now we have come to an end of our session today, and for this I invite Dr. Andrew PV from Department of Botany, St. Thomas College, for the vote of thanks.
Respected Principal Vijaykumar sir, our HOD Vimala Jose, Reverend Dr. Anil K, Dr. John Snadu, my colleagues. Prelude patent. Vijaykumar sir was an excellent, very expert man in the patent. He's also age. Really, I have attended many higher class by Vijaykumar sir, a herbal painting, 30-hour course, very informative and inspiring that webinar today. Link personality. And
So your voice is
also
breaking.
explain the synergetic effect of patenting. So a wonderful class that was very memorable for our department and who participated in this program. So I extend my gratitude and thanks to Vijaykumar sir. Thank you, sir. Then our principal. Is this clear?
Yes, sir.
Adira?
Now it's okay.
Our principal inspired for this webinar and give very warm support and also inaugurated this program with timely. And so I extend gratitude to our principal, Reverend Dr. Martin K.A. Then our HOD, Vimala Miss. She is also very supportive and give many helps to this program. So I formally giving a thanks to Madam. Then our accuracy coordinator, Dr. Anil Kongoth, who is shoulderly support me to conduct this event. So I give great thanks to sir, my colleagues, and my MSc students, research scholars, and other faculties from other colleges, and students of other colleges, research students of other colleges. Also give thanks to this opportunity and join the program and give support to St. Thomas College. So I once again thanks to our student coordinators and conveyors, and also my colleagues of departments for very good support, and all these efforts become least. So I give thanks to all once again. Once again, I repeat my thanks to all. Thank you.
Thank you, sir. Now the session has been dispersed, and thank you all for your participation. Thank you.
Thank you, everyone. Bye.